A very good evening, everyone. A quick audio check. Am I audible to everybody? Yes, audible, visible. The presentation is also visible on your screens, everyone. Yes, can I get a quick yes? Yes, okay. Thank you, Hasika. Thank you, Sindhija. Very good evening to everybody. Oh, thank you so much, Hasika. Today is a very important day for us women in India, at least in certain parts of North India, जहाँ हम लोग आज करवा चौथ मना रहे हैं. Hence you see me in a different avatar today. I've got mehndi and everything. And in fact, we had planned these Thursday to Thursday sessions. Otherwise, I wasn't really in a mood to talk today. Okay. So if I'm talking today, you guys should be really happy about that. Okay. Chalo. So today we're going to start with procedural laws. And let's begin. So this session, I will introduce you the concept of what procedural laws are about. And then we will also do a CRPC. Like that's your code of criminal procedure. Those are the only two things we are going to deal in today's session, right? Chalo, let's begin. Now, before I move on to my next slide, does anybody know that there is something called procedural law? Can anybody give me an example of procedural law? I'm like, it's right there in front of you, but still, can you give me another example of procedural law? Can you tell me what is procedural law as opposed to what? Because they're normally, two categories of law which are kind of put against or pitted against each other. One is procedural law, and uska opposite kya hota hai? What kind of law is that? You do get questions on this concept which are very, because these are very basic kind of session that we're going to have. We're not going to go into the details of the code of criminal procedure, but certain basic concepts which will help you not only in a question on procedural law, but any kind of miscellaneous law question, any question which comes on, let's say, any kind of current legal affairs and things like that also. Yes. Supriya, no, not penal laws. Rashika, you're right, Bacha, it is substantive laws, right? So when we are talking about this kind of categorization of laws, here, what are we referring to? We are referring to a system wherein we are dividing law into two categories. One would be substantive law and the other is a kind of procedural law. Now, when we talk of substantive law, what substantive law does, it defines rights and liabilities of individuals and collective bodies. Basically, it has the duty of defining your rights and liabilities. It tells you that this is a particular right which you have, and if you have this right, then it would in result mean that it becomes somebody else's liability, right? So this right and liability, any law which gives you the rights and liabilities are your substantive laws, right? Like the biggest example of substantive law is when we look at IPC. I'm taking up IPC especially since we are going to do CRPC today. That's your criminal procedure code. Now, when you look at the IPC, what does it give you? Kya karta hai? What does the IPC do? Can anybody tell me? आप लोग ने सबने, I'm sure IPC पढ़ा है criminal law की classes में. You're preparing for your CLAT, so there is a lot of stress on criminal law also in your preparation. So IPC करता क्या है? What is contained in the IPC? What does it do? Can anybody help me out a little? कि मतलब IPC में लिखा क्या हुआ है? आप लोग पढ़ते हो IPC के sections, उनके अंदर जो भी होता है. What does it do? What is it that the IPC gives you? What is provided under the IPC? Okay, Supriya is telling me it explains laws or crimes and gives punishment. So IPC basically explains crime, punishment and crime. Okay, Chahat is telling me punishment and crime. So IPC क्या करता है? IPC basically define करता है कि भाई अलग-अलग type के crime क्या है. If somebody takes away your property without your consent, then in that case, he has committed theft. तो अब ये theft, if this provision was not there, if somebody takes away your property without your permission, क्या कुछ कर सकते थे उसके? कोई criminal action ले सकते थे? नहीं. The only reason why you can take criminal action because of the fact that somebody is taking away your property without your consent, it is a crime because it has been defined as one. So in effect, what is this definition doing of crime? It is giving you right. It is giving you a right that if somebody takes away your property without your permission, then you can file a case of theft against that person. That is your right. Similarly, इसमें फिर liability भी होती है. अगर आपने theft commit करा, तो फिर क्या punishment होगी, right? Or what is going to be the consequence? That is going to be the liability, right? And it is across the board. It's not just with IPC. IPC is one example. Majority of the laws that are there in our country are substantive in nature. हमेशा कोई और किसी भी और लॉ का एग्जांपल लो जो आप लोग पढ़ भी रहे हो. लेट्स टेक अप द एग्जांपल ऑफ टॉर्ट लॉ. टॉर्ट लॉ में क्या होता है? अब वहां पे भी इट इज क्रिएटिंग अ राइट कि अगर किसी ने ड्यू केयर नहीं लिया, a person is supposed to take due care, he owes a duty of care to you, he does not take care, then he is going to be liable to pay damages. So in effect, ho kya raha hai? It is creating a right and a liability, right? So whenever we are talking about substantive laws, any laws which create rights and liabilities, like you're doing contract में क्या होता है? आपकी right create होती है by if you enter into a legally binding contract. Now, if you're entering into a legally binding contract, immediately thereafter, what happens is, अगर दूसरे बंदे ने breach commit करा, then you have the right to ensure that the contract is enforced या आपको damages मिलते हैं. So all those are your rights and liabilities which are created under substantive law. So substantive law, टाइप ऑफ लॉ, कैटेगरी ऑफ लॉ जो कि राइट्स एंड लाइबिलिटीज क्रिएट करता है. अब होता क्या है कि आपके पास राइट एंड लाइबिलिटी तो है, बट अब what should be the next step? What should I do next? अब मेरे पास I know I have this particular right that अगर मेरी प्रॉपर्टी किसी ने ली है, that means he can be held liable for theft. So what do you do thereafter? Theft के बाद क्या करोगे? Theft तो हो गया. What's the next step that you would take? Can you tell me what is the next step that you're going to take? एक बार theft commit हो गया, फिर आपको पता है कि इसको punishment मिलनी चाहिए इसके लिए. This is a crime which has been committed. So what is the next step that you're going to take? Does the IPC tell you about the next step? कि अगर theft commit हुआ है तो भाई अब क्या करोगे? Like मेरे घर में theft commit हुआ, मुझे क्या करना चाहिए? Does the IPC tell me that? Yes or no? No. IPC does not tell me that. Sindhuja is telling me file an FIR. हसिका बोल रही भाई कंप्लेंट फाइल करो. भाई FIR फाइल करनी है या कंप्लेंट फाइल करनी है या इनमें से कुछ भी नहीं फाइल करना है, ये मुझे कौन बताता है? Procedural law will govern the process, right? It will govern the process of determining the stipulated rights and liabilities of the parties, right? तो यहाँ ये बताता है कि भाई आपकी एक बार राइट या लाइबिलिटी तो सब्सटैंटिव लॉ ने बता दी है, उसके बाद हाउ आर यू गोइंग टू गेट इट एनफोर्स्ड, राइट? तो आपका जो एनफोर्समेंट वाला एस्पेक्ट है, what do you do, how do you get it enforced, all that is now covered under the procedural laws. It tells you the entire procedure कि भाई कैसे कैसे आपकी rights and liabilities determine होंगी, because this is very essential. Because if you look at the concept of substantive law, वो तो बहुत अच्छा है कि भाई theft हुई है, then the person should be punished and you should get some relief. That is fine. But then how do you ensure that कि ये जो theft के लिए केस जो चलेगा, ट्रायल जो चलेगा, वो फेयर ट्रायल है, उसमें सब कुछ ठीक हो रहा है, ड्यू प्रोसेस ऑफ लॉ हो रहा है, or that that there is no somebody is not being framed wrongly or something like that. ऐसा कुछ तो नहीं हो रहा है. All that is ensured by your procedural law. Because procedural law आपको पूरा का पूरा procedure समझाता है, whether it's a civil case or a constitutional law case or a criminal case, any type of case, the procedural law will tell you what is the procedure for filing a particular case, and thereafter जो पूरा का पूरा trial होगा उसका procedure क्या होगा, that is going to be your procedural law, right? Now here when you look at substantive law, it says no independent powers without procedural law. Now here, if it is a substantive law, if the procedural law is not there, would you be able to enforce your right? You need some sort of a procedure. Just because I have a right over my property, merely having a right over my property is not sufficient. How do I enforce that right? Right. So that is why procedural law is something which is very, very crucial when you are talking of ensuring कि आपके substantive right जो है वो आपके लिए चलते रहे, right? Next is when you're talking about independent. अच्छा, on the other hand, जब आप procedural law को देखते हो, तो procedural law क्या है? Independent powers to decide the fate of the case. Here, once you know that, okay, the substantive law has given a right to you, thereafter, what is going to be the ultimate, ultimate decision? As in, should the person be held guilty, not guilty? All that is independent as far as the procedural law is concerned, right? So the procedural law will decide कि भाई finally क्या आपका guilty होगा, not guilty होगा, damages मिलेंगे, नहीं मिलेंगे. So all those rights and those liabilities, finally the decision is of the procedural law, right? Similarly, when you talk of substantive law, it says it has the power to offer a legal solution. Right. So in the sense that agar, like, I'm still sticking to my example of theft because I feel it's a nice one. So if you still think of that theft wala example, अब जब theft commit हो रहा है, तो IPC क्या कर रहा है? आपको define भी कर रहा है crime और साथ में आपको solution भी दे रहा है in the form of a punishment, right? So the substantive law will define and it will also give a solution. Whereas जो procedural law है, that will only describe the legal process कि finally ये पूरा का पूरा जो है, how is it going to be executed, right? It does not give you rights as such. Procedural law will only provide the procedure. वो सिर्फ बताएगा कि कैसे कैसे अपना right enforce कर सकते हो, वो आपको right create करके नहीं देता. That's the very basic differentiation between the two. Right. So whenever you look at substantive law, all this is again, we're talking about the same thing. It says it provides the mechanism for giving effect to it. Whereas when you look at substantive law, it is giving you rights and liabilities. This is what we discussed, the criminal law aspect of it. Okay. Now, today's session, what we are basically going to be discussing is your Criminal Procedure Code of 1973. I hope till here everybody is clear. This is fairly simple. This is something which most of you must have come across somewhere or the other, right? So now we are going to go on to specifically procedural laws. Now, when you look at procedural laws, these are some of the major procedural laws in our country. This is not an exhaustive list, okay? Procedural laws और भी बाकी काफी सारे होते हैं, but they would be specific to certain specific type of wrongs, right? However, when we are looking at from the perspective of CLAT, कौन से मेजर प्रोसीजरल लॉज हैं जिनके बारे में आपको थोड़ी इंफॉर्मेशन होनी चाहिए? Those are basically going to be your CPC, CRPC, little bit of idea on evidence, not too much, just a little bit of idea on what the Evidence Act is all about, little similar idea on limitation, court fees and valuation. I'm giving more like examples. This is not what we will be focusing on, right? तो अगर क्रिमिनल केस है तो उसका प्रोसीजर क्या होगा आपको सीआरपीसी बताएगा, सिविल केस है उसका प्रोसीजर सीपीसी बताएगा. दोनों में एविडेंस कैसे लिया जाएगा और what is the manner in which evidence is going to be brought before the court, or whether a particular document or a particular person's testimony can actually be taken as evidence or not, right? So both the things will come into play here when you talk of evidence. because evidentiary law is something which will tell you what can, because everything you cannot bring in evidence. Everything under the sun is not something which should be admissible in evidence. Otherwise cases तो prolong ही होते रहेंगे. Imagine कभी, again I'm going back to my theft का example, ठीक है? तो मान लो theft का case हुआ and you want to prove the other person is not guilty of theft. तो आपने क्या किया, आपने जाके कोर्ट में 10 विटनेसेस लेकर आ गए आपकी, भाई इसने थेफ्ट तो कमिट करा ही नहीं हो सकता बिकॉज ही सच अ गुड गाय, राइट? सो पुटिंग ऑल दोस 10 पीपल इन द विटनेस बॉक्स, इंश्योरिंग कि सबकी टेस्टिमनी हो, पहले एग्जामिनेशन हो, फिर दूसरी साइड से क्रॉस एग्जामिनेशन होगा, वो सब क्या वुड इट बी रियली एसेंशियल? अगर आपको उसकी you just want to prove how good a fellow he is, तो एक या दो विटनेस चलेंगे. So there has to be some sort of a semblance as कि आप कुछ भी एविडेंस में नहीं ला सकते हो कि जो आपकी मन में आए वो आप एविडेंस एज एविडेंस कोर्ट में पेश कर रहे हो. That is something which cannot happen, right? So the Evidence Act, that's your Indian Evidence Act, this is the law which will kind of tell you कि भाई ये चीज आप एविडेंस में आप प्रोड्यूस कर सकते हो बिफोर अ कोर्ट. दिस इज समथिंग which cannot be produced before a court as evidence, right? So ये सारे के सारे जो एविडेंस रिलेटेड लॉ है, और कैसे होगा एविडेंस, अगर आपने कोई डॉक्यूमेंट प्रोड्यूस करना है तो किस फॉर्म में वो प्रोड्यूस होगा कोर्ट में, अगर आपने किसी को विटनेस लेके आना है तो उसके लिए क्या प्रोसीजर होगा, कैसे उसकी टेस्टिमनी रिकॉर्ड होगी, ये सारी की सारी चीजें जो है आपकी इंडियन एविडेंस एक्ट में दी हुई है. नाउ योर CPC and your CRPC, both of them have a same evidence law, right? So whether it is CPC, talking about Civil Procedure Code, or you're talking about the Criminal Procedure Code, basically चाहे civil case हो, criminal case हो, दोनों के लिए evidence का law same होता है. You have only one evidence act. You don't have separate law of evidence for civil and criminal cases. This is next. This is the third type of important procedural law. जो चौथा है आपका, that is your Limitation Act. Now, what does the Limitation Act do? Limitation Act provides you this. I think most of you would be aware of because ये हम पढ़ते हैं जब आप contracts पढ़ते हो. Can you tell me what is limitation and contract से इसका relation कैसे आता है? It will just show me कि भाई कितना कौन पढ़ाई कर रहा है. Good, Supriya. That's one angle. Very nice. And कहाँ लिमिटेशन एक्ट में हमने कॉन्ट्रैक्ट्स पढ़ा है, या लिमिटेशन एक्ट है क्या? what does limitation act do? I'm like, what is the purpose that it serves? What is the objective that it serves? Supriya is right in what she has written. Supriya ने बोला कि भाई टाइम बार्ड डेट्स होते हैं, कुछ ऐसे डेट होते हैं जो कि टाइम के बाद बार हो गए. दैट मीन्स यू कैन नॉट एनफोर्स द राइट बिकॉज वहां पे लिमिटेशन लॉ लग गया. लिमिटेशन लॉ क्या बोलता है, लिमिटेशन एक्ट क्या बोलता है कि भाई स्पेशली दिस इज विज़ सिविल सूट्स एंड नॉर्मली वी टॉक ऑफ अपील्स वगैरह में काम आता है लिमिटेशन एक्ट एंड सिविल केसेस में, कि भाई एक टाइम पीरियड है विद इन विच यू कैन फाइल योर केस. तो अगर आपका ब्रीच ऑफ कॉन्ट्रैक्ट लेट्स से हैपेंड इन 2005, right? So the breach of contract happened in 2005. Till when can you file a case? So usually for a contract, normal contracts, the limitation period given under the Limitation Act is 3 years, right? तो 3 साल के बाद आप केस फाइल नहीं कर सकते. That means 2008 तक आप केस फाइल कर सकते हो. Can you file a case in 2020 against a debt which was due in 2005? Can you do that? कि भाई 2005 का केस था, आप 2020 में केस फाइल कर रहे हो, 2005 में उसने डेट जो है डिफॉल्ट करा था. Can you file a case in 2020 now? No, you cannot. Why? Because the limitation period is over, right? So that's what the Limitation Act talks about. एक बार ये 2020 आ गया तो क्या हो गया, वो debt barred by time हो गया. That's a time barred debt, right? I'm not going into how that concept comes in your contract exam because that is something which you will do in your contract class, not here, right? But generally जब आप contract पढ़ते हो तो आप limitation के बारे में थोड़ा सा आपको ज्ञान मिलता है, right? Okay. On the other hand, जो last two हैं ये एकदम नए हैं. Court Fees Act. Now Court Fees Act क्या बोलता है कि especially again this is a civil law में काम आता है. If you're filing a civil case, then there is a certain amount of fees which you need to pay to the court when you're filing a case. Why do you think you need to do this? कोर्ट बोल रहा है कि अगर आपको सिविल सूट फाइल करना है, then there is a certain amount of fees which you need to first pay to the court. फीस कोर्ट में डिपॉजिट करोगे, उसी के बाद जो है कोर्ट आपका केस सुनेगा. What would be the reason? Why do you think you need to pay this court fees? And I'll give you one clue कि जो भी आपकी कोर्ट फीस होती है, that is basically dependent on the valuation of the suit. तो ये जो यहाँ चीज आई है, सूट की वैल्यूएशन, की वैल्यूएशन जो होगी आपके सूट की, which means that how much is the suit worth, कि आप जो पैसे उसमें क्लेम कर रहे हो, या जो मान लो आप बोल रहे हो मेरी प्रॉपर्टी है, and there's a dispute between A and B regarding a property, और ये जो प्रॉपर्टी है, you are claiming that this property is worth 10 crores. तो आपका डिस्प्यूटेड अमाउंट कितना है? 10 crores. तो आपका सूट का वैल्यूएशन कितना हो जाएगा? 10 crores, right? So you have this law, which is the Suits Valuation Act, which tells you कि अलग अलग टाइप के सूट्स की वैल्यूएशन के क्या टर्म्स एंड कंडीशंस होंगे, आप कैसे अपने सूट को वैल्यू करोगे, right? And depending on कितना आपका वैल्यूएशन आया है, उसी के ऊपर डिपेंडेंट आपकी कोर्ट फीस होती है, because it's supposed to be like a percentage of the valuation of your case, right? So that is your court fees and valuation. So tell me, why do we need court fees? Can anybody tell me ये court fees है क्यों? अब मैंने आपको बता भी दिया कि भाई court fees लगती कैसे, valuation के हिसाब से सूट के. So why do you need court fees? What is the purpose behind having this concept of court fees? What is the purpose? क्यों होता होगा कोर्ट फीस? एक बार ये जो केस तो शुरू हो गया, ओके, oh, very good, Chahan. You know, you just hit it right, bang on. क्या बोलते हैं इसको? You hit the nail on the head, right? So here, Chahat is telling so that people file a reasonable case. Very important to ensure that frivolous litigation ना हो, to ensure that कोई ऐसा litigation किसी को तंग करने के लिए ना करे. You know, malice now. It shouldn't be not just in order to create trouble for some person. So that whenever you're filing a case, the case is genuine. So if you're saying that the dispute is worth 10 crores, you're willing to pay close to 10 lakhs as your court fees, right? So only and only if you're willing to pay this, will you be allowed to file a case of 10 crores, so that people find a reasonable case. So that, you know, this is again, we say that it is something, it's a instrument against vexatious litigation in which the intention is not to right what has been wronged to you, but the intention is to trouble the other party, right? तो vexatious litigation को कम करने के लिए, frivolous litigation को कम करने के लिए, malice ना हो, आपका यहाँ court fees का concept arise होता है, right? So these are the basic procedural laws in our country. These two are not very important so far as your CLAT exam is concerned, but generally 1, 2, 3, 4 इनके ऊपर हमने questions आते हुए देखे, right? You know, in the PYQs also you must have come across questions on these. So today what we're going to start off with is your Code of Criminal Procedure, right? So this is what we are going to do today. So let's begin. So when you are talking about the Code of Criminal Procedure, अब इसको normally हम common parlance में CRPC बोलते हैं. You don't have to worry, CRPC बोलो या Code of Criminal Procedure बोलो या Criminal Procedure Code बोलो, it's one and the same thing that you are talking about. उसमें कोई अलग नहीं है नाम अलग बोलने से, ठीक है? Now here are some of the objectives, or what is the purpose behind the CRPC? What is it that you try to achieve through the CRPC? Now, the first and very, very important part is that you want to ensure a fair trial, right? And it is both for the accused as well as the victim. तो दोनों की तरफ से you would want that, okay, you're saying that this person might have committed this particular wrong, आपने किसी को accuse करा है, but जिसको आपने accuse करा है उसके पास भी right होना चाहिए to ensure that he's got the right to represent his case. And there is nothing unfair which has happened to him. He's not been unnecessarily been framed for something which he hasn't committed. Similarly, victim ke hisab se bhi, the person who suffered from that injury, for him also, there should be a fair trial, right? So normally we say that principles of natural justice should be met with. Natural justice ke principles kya hote hain? These are supposed to be used everywhere. In any kind of case, these are like universal principles. Can anybody tell me universal natural justice ke principles kaun se hote hain? Just name there are 2 or 3 principles, 3 odd principles of natural justice. To be heard and no bias. Good. Supriya is saying me that you have the right to be heard. This commonly, it is also known as that audi alteram partem. Right? So जब audi alteram partem होता है, तो आप क्या बोलते हैं? You have the right to be heard. Right? Similarly, there is one in which he says there should be no bias. जिसमें वो दूसरा वाला आता है. You have that nemo judex insua causa. That one is there. Right? So that is your natural justice when you're talking about there should not be bias. Basically, nobody can be a judge in his own case, and यहाँ पे everybody has a right to be heard before a decision is given. Similarly, एक और आता है इसका. Anybody has any idea? Reasoned decision. Good. Reasoned decision is the third basic principle of natural justice. See, uske alawa you might come across some other concepts also which might be said to be part of natural justice, but generally, universally, these are the 3 principles jo ki natural justice ka part mana jata hai. That there has to be a reasoned decision, also popularly known as a speaking order, audi alteram partem and no bias, right? So ये 3 चीजें हैं जो कि होनी चाहिए. तो जब CRPC को भी देखते हो आप, in CRPC, the provisions are made in such a manner that all the principles of natural justice should be met, right? So all the parties, both the accused and the victim, are given a chance to be heard, right? Then when you're looking at who is going to hear the matter, there is a proper system. There is the CPC gives you the organization of criminal courts. Now, since we have a uniform criminal law in our country, so there is a uniform system of courts also. So, भाई कौन से courts, hierarchy क्या होगी courts की, कौन से court के पास क्या power होंगी, that is something which is uniformly provided for in the criminal procedure code. So that will ensure कि कोई bias ना हो. That will ensure that there is a fair hearing which is given, right? Next, when you look at the objective, it says to prevent delaying the investigation and trial process, right? So here it provides you with time frame also कि भाई कितना आपको कौन सा केस कब फाइल कर सकते हो, what are the time durations and everything. So you, in order to avoid any kind of delay in investigation and trial process. फिर आपने सुना होगा concepts like warrant, summon issue हो गए हैं, warrant issue हो गए हैं. What is the purpose of those? To ensure attendance, right? So because if a trial is going on, पता चला जो accused है वो गायब हो गया. अब वो गायब नहीं होना चाहिए, he should be there. So that is when concepts like warrant and summons come into play. If you want that for in the criminal trial, certain person has to be brought in to give evidence. तो वो evidence के लिए भी आप summons issue कर सकते हो. आप summon करोगे इस बंदे को, the court will summon the person and the person will actually have to come before the court and give his evidence. So all this procedure is just to ensure कि justice is being done. Finally, ultimate aim है कि fair case होना चाहिए, fair trial होना चाहिए, justice has to be done, right? So it gives you the procedure for the functioning right from the stage of investigation to the conviction and the process for appeal also. तो criminal case में appeal कहाँ जाएगी? Right from the stage of investigation, right? So normally that is why if you look at the CRPC, अगर आप जब आप college में जाओगे, 3rd 4th year में जब CRPC उठा के actually पढ़ोगे, तो आप realize करोगे कि भाई पुलिस के पास क्या power है investigate करने की, या to ensure that they have to write the complaint which you make. So ये पुलिस की ऊपर लाइबिलिटी है, पुलिस की सर्टन राइट्स है इन्वेस्टिगेशन करने के टाइम पे, all those also are also provided within the CRPC. तो जो CRPC है वो सिर्फ कोर्ट के प्रोसीजर की बात नहीं करती है, इट इज गोइंग बियॉन्ड द प्रोसीजर ऑफ कोर्ट, राइट? इट स्टार्ट्स फ्रॉम हाउ यू विल फाइल द केस, राइट? हाउ विल यू फाइल द केस, पुलिस की पावर्स क्या है, या आप पुलिस की जगह कई बार मैजिस्ट्रेट के पास भी केस फाइल कर सकते हो. सो ऑल दिस इज वेयर द CRPC begins, right from the start. Then investigation होगा, conviction होगा, अपील भी. आप क्रिमिनल केसेस में कैसे कैसे अपील फाइल कर सकते हो, कहाँ पे अपील फाइल कर सकते हो, तो ऑल दैट इज ऑल्सो प्रोवाइडेड विद इन योर CRPC, right? This is exactly what I was talking about right now, the role of and powers of police and other authorities in investigation and trial process. ये सारी चीजें डिटेल में CRPC में दी गई है. Right, so all this is provided very nicely in the CRPC की पुलिस की पावर क्या होगी during investigation, right? So and of course the powers of the courts also, कि भाई कोर्ट की भी क्या पावर होगी, कौन से कोर्ट होंगे, किस टाइप के केसेस हो सकते हैं, all that is provided in the CRPC, right? I hope so far so good. Let's move on. Now the next thing, when we look at the CRPC, important thing, especially, we are looking at things that are important from your CLAT perspective, is when you look at the first schedule. अब CRPC पूरा का पूरा एक्ट है, कुछ 400 कुछ सेक्शंस है उसमें, उसके बाद आता है उसका एक शेड्यूल which is attached in the end, and that schedule is very very important because पूरा आपने प्रोसीजर बता दिया, उसके बाद आपको ये अलग अलग टाइप के यहाँ पे उन्होंने they have given, there is a table, there is first schedule part 1 and first schedule part 2. तो first schedule के भी 2 पार्ट है, पहला पार्ट IPC को डेडिकेटेड है एंड दूसरा पार्ट अदर लॉज को डेडिकेटेड है. So when you're looking at this IPC first part and second part, what it does is in the schedule, it is a tabular sort of a format, पूरा टेबल बना हुआ है, ठीक है. इस टेबल में पहले लिखा होगा कि भाई आईपीसी का सेक्शन कौन सा है, देन देयर इज अ ब्रीफ जिस्ट ऑफ द सेक्शन, राइट? कि अगर मान लो थेफ्ट का सेक्शन है तो थेफ्ट के सेक्शन में थेफ्ट होता क्या है, सो 2-4 वर्ड्स में, एक लाइन में यहाँ पे ये भी दिया होगा. देन इट गिव्स यू वेदर अ पर्टिकुलर, देन इट ऑल्सो गिव्स यू द पनिशमेंट कि भाई क्या पनिशमेंट है इस पर्टिकुलर ऑफेंस की. सो इट्स गोइंग टू गिव यू कि मान लो अगर पनिशमेंट इज 2 years to 4 years and fine, right? So that is what is again mentioned in that table. उसके बाद क्या mention करता है, whether this offense is bailable or non-bailable. Similarly, it will also tell you whether this offense is cognizable or non-cognizable. And one more thing it will tell you is कि भाई कौन सा कोर्ट जो है इसको ट्राई कर सकता है, right? So which is the court in which this case is going to be heard, right? So this is a full blown description which is given for each and every offense of the IPC. तो जितना बड़ा CRPC है उतना ही बड़ा ऑलमोस्ट उसका शेड्यूल भी है, बिकॉज एक IPC के section wise it is given, right? Section by section it is clearly given, this is a bailable offense, this is a non-bailable offense, this is the punishment, and who has the right to try this, which particular judge or which particular magistrate actually has the right to try this particular case, right? So all that is given in your first schedule. And part 1 IPC की बात करता है, and then there is part 2 which talks of other laws. Other laws are basically they are giving as per the punishment, कि अगर punishment such and such है, मान लो 7 years या 7 years से above है, तो फिर वो bailable होगा या non-bailable होगा, cognizable होगा या non-cognizable होगा, and finally उसको try करने के लिए कौन से कोर्ट में आप केस फाइल करोगे, right? या फिर जो पुलिस है इन्वेस्टिगेशन के बाद कौन से वाले मैजिस्ट्रेट के पास केस जाएगा, and who would be the guy who would actually be deciding your case, right? So the entire procedure, this entire thing is given in your first schedule. So now let's understand each of these things concept by concept. कौन से कोर्ट है, we will do that in a bit, but पहले हम आ जाते हैं कि भैया bailable and non-bailable क्या होता है. When you are talking about an offense which is a bailable offense, a bailable offense is one in which bail is your matter of right, right? These are generally less serious in nature, बहुत serious offenses नहीं है, but here you are getting bail as a matter of right. So Priya, I'll just come to your doubt in a little bit, bacha. Right? So don't worry on that. I will just come to that. Now, here when you're talking about bailable and non-bailable, here bail is a matter of right, which means that if you are being charged or you've been accused of such an offense, you will be given bail, right? It cannot be said that you will not give you bail. You will have to be given a bail. On the other hand, जब हम non-bailable offense देखते हैं, these are the offenses in which bail is not available in general. बट कोर्ट के पास फिर भी डिस्क्रिशन है केस में अपील फाइल बेल देने का. तभी जब आप बोलते हो ना आप बेल एप्लीकेशन फाइल कर रहे हो कि कोर्ट में बेल एप्लीकेशन लगी है, तो वो कौन से वाले ऑफेंसेस के लिए होगी? when you're filing an application to get bail, would it be for a bailable offense or a non-bailable offense? When you're filing an application in the court to grant bail, tell me, कौन सा होगा फिर? Will it be will you call it a bailable offense or will you call it a non-bailable offense? Which one would it be? Then it is going to be a non-bailable offense, right? Non-bailable offenses कौन से होते हैं? Non-bailable वो होते हैं जिनका कोई भी वो नहीं होता है, क्या बोलते हैं, जिनमें discretion है कोर्ट का. It is not a matter of right. You have a matter of right only in bailable offenses. ठीक. अच्छा, अब bailable offenses क्योंकि आपको matter of right bail मिल रहा है, so obviously they are less serious in nature, whereas non-bailable are supposed to be more serious in nature. Similarly, आपका cognizable and non-cognizable offenses आते हैं. Cognizable are those in which a police officer may arrest without a warrant. तो cognizable offense वो है जहां without warrant भी पुलिस आपको arrest कर सकती है. तो tell me, ये serious होंगे या non-serious होंगे? So cognizable offenses would be serious offenses or non-serious offenses? क्या होंगे? Would it be, in comparison to a non-cognizable offense, would it be more serious or less serious? I know this always confuses everybody. बच्चा, अगर आपको अरेस्ट कर रहे हैं विदाउट वारंट, तो कोई छोटी सी अगर आपने गलती करी है, तो वहां पे क्या पुलिस के पास राइट होना चाहिए आपको अरेस्ट करने का? नो. आपको अरेस्ट करने का राइट पुलिस के पास कहाँ होना चाहिए? जहां ऑफेंस जो है वो बहुत सीरियस है, right? If it's a serious sort of an offense, then the police will have the right to arrest you. On the other hand, if it is not a very serious offense, then the police will not have the right to arrest you, right? So therefore, अगर मान लो murder trial है and you've been accused of murder, तो वहां पे will it be a cognizable offense or a non-cognizable offense? If it's an offense for murder का offense है, तो क्या होगा? Cognizable offense होगा या non-cognizable होगा? Obviously, it is going to be a cognizable offense because it is very serious in nature. So any kind of offense which is serious in nature is generally cognizable. But यहाँ पे आपको इतना confuse होने की जरूरत नहीं होती है. As a lawyer also, as a court also, मतलब हर बार ये कैसे decide करते हो कि भाई कौन सा serious है, कौन सा serious नहीं है. तो इसीलिए यहाँ पे जो first schedule है वो चीज को आसान कर देता है. Right? So every offense, whether it is a bailable offense, non-bailable offense, whether it is a cognizable offense or a non-cognizable offense, right? So this is what the first schedule basically talks about, right? Gives you this detail. Now let's move on. Now next is when you are talking about the type of trials. Now here I was telling trialable by which court, उसमें भी आते हैं. उसके बाद होते हैं अलग-अलग type के trials होते हैं. Now okay, Hasika has a query here. It says, why? Because, ma'am, why? Because if he has murdered someone and it's still not proven in court, then why is it a cognizable offense? See, since it's a serious offense, and if the police has certain substantial amount of evidence, police ko investigation ke baad लगता है, they have, a certain prima facie belief that this person has committed the particular wrong, then you would want कि such a person should be arrested. यहाँ पे वारंट लाने की लिए वेट नहीं करना पड़े उसको. It is not that the person is not going to be tried. He is going to be tried, but it is for a greater good. कि ऐसा नहीं है कि उसने एक बंदे का मर्डर करा है and by the time the police gets a warrant and arrest him, by then he's committed 2 more murders. And so you want to avoid that situation, because here we are looking at it from a greater good perspective. And even if the person has been arrested, it does not mean he has been held guilty. Trial to usko milega, fair trial to hoga. But just in the interest of justice, just to ensure that koi aur wo dobara commit na kare the same offense or something, there's no repetition, you can arrest him without a warrant. Okay? So that is the idea. ओके, अब आ जाते हैं हम टाइप ऑफ ट्रायल्स पे. अब पहला यहाँ पे क्या दिया है, अ वारंट केस. नाउ व्हेन यू लुक एट अ वारंट केस क्या होता है? इट इज अ केस जहां पे आपकी पनिशमेंट क्या है? डेथ, imprisonment for life, or imprisonment exceeding 2 years. Right? So any case in which basically if the punishment is for more than 2 years, it is considered as a warrant case. A warrant case. Now, why is the difference between a warrant case and a summons case? Because इन दोनों का जो trial का procedure है, वो थोड़ा अलग होता है. Right? Here it is going to be a more detailed procedure rather than a summons case. Like here, if it's, let's say, a warrant case can be started in 2 ways. Either it begins while filing of an FIR. तो ये आपने पुलिस के पास FIR फाइल करी, or you could even start a warrant case by filing it before a magistrate, right? तो आपने सीधे magistrate को complaint file करी. These are also known as complaint cases. There are certain kind of wrongs जहाँ पे complaint करना directly allowed होता है. This is all given in the CRPC, right? You don't need to know कि कौन से में क्या होता है. I can give an example. Like if you're filing a case of defamation, you can file an FIR, but you can even file a complaint before the magistrate, right? So there are certain wrongs जो कि complaint case से शुरू होते हैं और कुछ FIR से शुरू होते हैं. But दोनों में eventually होता एक ही चीज है. After the magistrate goes through the case which has been filed, he peruses the evidence, की evidence जो भी parties ने लाके दिया है. Similarly, अगर FIR file हुई है तो investigation होगा. Investigation के बाद case दोबारा magistrate के पास आ जाएगा. And magistrate यहाँ पे क्या करता है? Charge frame करता है. Right? So whenever we are learning about, जब हमने पहले भी malicious prosecution के time पे, we had spoken about कि trial का prosecution का procedure क्या होता है. तो normally there is either a police complaint or an FIR, and then the magistrate will hold a hearing of charge और फिर उसके बाद पूरा का पूरा trial होगा. Right? So that is the procedure for a warrant case. Right? तो वो warrant case के लिए है, any case where the punishment is exceeding 2 years is considered as a warrant case. On the other hand, any case जहाँ पे punishment less than 2 years है. So again, these are cases which are little less serious. तो वहाँ पे you don't, the procedure is going to be a little different from a warrants case, right? So here the magistrate will not call upon both the parties कि भाई अपना केस प्रेजेंट करो और फिर चार्ज फाइल होगा. वहां पे they can issue a notice even without giving both the parties an opportunity to be heard. Because when you talk about a summons case here, these are less serious in nature. Right? So less serious in nature hai, the procedure would be simpler. Here, warrant cases, they are more serious in nature, therefore procedure is more complex. And that's the basic idea you need to have, that warrant case, more than 2 years, more complex. Summons case, less than 2 years punishment, then it is going to be less complex. Right? So that is going to be your warrant and summons case. Right? इसके अलावा 2 और टाइप के केसेस होते हैं. One is your summary case. Oh, I am sorry. I think there's some little this thing. This should not be summons case actually. This should be sessions case. ये गलत आ गया. This should be a sessions case. ओके, सेशंस केसेस वो होते हैं जहां पे आपका पनिशमेंट इज आइदर डेथ पेनल्टी or imprisonment for life or more than 7 years. So all these cases in which the punishment is either death, life imprisonment, or more than 7 years imprisonment, then in that case, such a case is going to be heard by the sessions court only, right? Such a case is not heard by any other court. कोई मैजिस्ट्रेट जो है, बिकॉज नॉर्मली जब आप डेथ पेनल्टी या लाइफ इम्प्रिजनमेंट की बात करते हो आपको मर्डर के केसेस याद आते हैं, है ना? तो जब आप मर्डर का केस ट्राई कर रहे हो तो मर्डर का केस कोई और मैजिस्ट्रेट ट्राई नहीं कर सकता. मर्डर का केस कौन ट्राई करेगा? सिर्फ सेशंस जज, राइट? सो इट इज गोइंग टू बी द सेशंस जज हु इज गोइंग टू ट्राई अ केस ऑफ मर्डर एंड नॉट एनी अदर काइंड ऑफ कोर्ट, राइट? सो ये वाले केसेस इसलिए स्पेशली इनको सेशन केस बोलते हैं. दीज आर वेरी सीरियस इन नेचर, राइट? सो दे आर कॉल्ड सेशंस केसेस, राइट? सो इवन इफ अगर मान लो केस आपने पुलिस कंप्लेंट फाइल करी है या आपने मैजिस्ट्रेट को केस फाइल करा, बट इवेंचुअली इट अनफोल्डेड कि भाई ये तो मान लो एक्सीडेंट हुआ था, राइट? या द पर्सन हैड बीन स्टैब्ड एंड व्हेन द केस वाज फाइल्ड द पर्सन वाज स्टिल अलाइव इन द हॉस्पिटल, बट देयर आफ्टर द पर्सन डाइड. तो अभी तक तो वो सेशन जज का केस नहीं बन रहा था, but eventually because of maybe the change in circumstances the case now becomes a sessions judge case. Then the case would now be transferred to the sessions court, because if this is the kind of penalty for the offense, then it can only be heard by the sessions judge and none of the lower judiciary other than the sessions judge can hear this case. ठीक? फिर आता है समरी केसेस, इसको समरी ट्रायल भी बोलते हैं, राइट? तो समरी ट्रायल क्या होते हैं? दीज आर ट्रायल विच आर ओनली फॉर वेरी स्मॉल ऑफेंसेस, राइट? सो वेरी स्मॉल ऑफेंसेस में कई बार जो आपका स्पीडी रेमेडी के लिए आइडिया है कि छोटे छोटे अगर ट्रिवियल केसेस हैं तो उसके लिए बहुत लंबा केस नहीं चलना चाहिए, फटाफट केस हो जाना चाहिए, राइट? तो यहाँ पे समरी केसेस या समरी ट्रायल में प्रोसीजर और भी छोटा होता है एंड दीज आर फॉर पेटी ऑफेंसेस. इनफैक्ट जहां ये आपके सीआरपीसी में समरी ट्रायल का दिया वहां पे दे हैव गिवन इफ इट इज अ केस ऑफ थेफ्ट, then if it is for less than 2000 rupees कि जो आपने चोरी करी है वो सिर्फ 2000 या 2000 से कम की है, तो फिर इतना लंबा फ्रेमिंग ऑफ चार्ज करके पूरा का पूरा वारंट केस जैसे ट्रायल नहीं चलेगा. आपका ट्रायल जो है वो छोटा हो जाएगा. इट विल बी इन द नेचर ऑफ अ समरी ट्रायल, राइट? सो दैट सिंस द offense is not very serious in nature, right? So the offenses are small because end of the day, when you are looking at the criminal procedure system या कोई भी आप अगर प्रोसीजरल सिस्टम देखते हो तो इम्पोर्टेंट क्या है? दैट जितना बिगर द ऑफेंस द मोर रिजिड और द मोर द स्क्रूटिनी शुड बी हायर सो दैट द एरर और द स्कोप ऑफ एरर इज रिड्यूस्ड, राइट? तो जब आप इसीलिए क्रिमिनल ट्रायल के भी अलग अलग टाइप देखोगे, all of them are dependent upon how heinous, how serious the offense is, because any which is in our country especially, we have so much of pendency. तो अगर हर छोटे छोटे केस के लिए भी आप प्रॉपर वारंट केस चलाने लग जाओगे तो बस कभी जो इतनी पेंडेंसी है वो डबल ट्रिपल हो जाएगी, right? So that is why we have this specific type of systems for specific type of offenses, right? I hope this is clear. See, as such आपको कोई क्लैट एग्जाम में पूछेगा नहीं कि भाई वारंट केस क्या होता है या समन्स केस क्या होता है, बट यस इट कैन कम इन योर एग्जाम दैट when you are talking of these cases, that it could come in your exam as to the passage could talk about warrant case, summons case. वहां पे अगर आपको idea होगा then it will be much easier for you to comprehend, right? That's the basic idea behind this session. अच्छा, अब यहाँ पे कुछ important concepts दिए हुए मैंने CRPC के जो कि आपके हिसाब से important है. अच्छा, before we go on that, I just want to do a quick hierarchy. Even though we do hierarchy in the of criminal court a lot of times in our classes, criminal law की क्लास में भी करते हैं हम, कॉन्स्टिट्यूशन में भी कई बार करते हैं, इंट्रोडक्टरी क्लास में भी करते हैं. सो आई वांट दिस टू कम फ्रॉम यू. सो सबसे ऊपर एपेक्स कोर्ट ऑब्वियसली इज द हाई सुप्रीम कोर्ट. सुप्रीम कोर्ट के नीचे ऑफ कोर्स आता है हाई कोर्ट. हाई कोर्ट के नीचे क्या आता है? When you're talking about the lower courts, high court के नीचे अगर हम criminal case की बात कर रहे हैं, तो criminal cases में what is the next court high court के नीचे जो आता है? District court is a very कॉमन नॉमेनक्लेचर सुप्रिया. डिस्ट्रिक्ट कोर्ट तो कोई भी कोर्ट जो डिस्ट्रिक्ट के लेवल का है वो डिस्ट्रिक्ट कोर्ट होगा, बट जो क्रिमिनल केसेस में डील करता है, व्हाट आर दोस कोर्ट्स कॉल्ड? इट इज नोन एज अ सेशंस कोर्ट. गुड, इट इज नोन एज अ सेशंस कोर्ट, राइट? तो सेशंस कोर्ट होगा. सेशंस कोर्ट के नीचे क्या होते हैं? व्हाट इज अंडर अ सेशंस कोर्ट? सेशंस कोर्ट आ गया, उसके नीचे और भी कुछ लोअर हायरार्की होगी या सिर्फ एक सेशंस कोर्ट ही होगा? उसके नीचे भी कुछ होगा ना? तो सेशंस कोर्ट के नीचे क्या होगा? क्विक क्विक. Whenever we talk of courts in terms of criminal law, हमेशा judicial magistrate होते हैं, right? They are not called judges, they are judicial magistrate. So you will have judicial magistrate first class, you will have judicial magistrate second class, right? Now, one of these judicial magistrate first class will also be referred to as the chief judicial magistrate, right? So CJM जो होगा, chief judicial magistrate जो होगा, he is going to be like amongst one of the chief judicial magistrate फर्स्ट क्लास, राइट? तो सेशंस कोर्ट आएगा, सेशंस जज आएगा, या फिर आप इसको बोल सकते हो सेशंस जज के नीचे होगा चीफ जुडिशियल मैजिस्ट्रेट, देन जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास एंड जुडिशियल मैजिस्ट्रेट सेकंड क्लास. द सीआरपीसी इटसेल्फ प्रोवाइड्स कि भाई ये अलग अलग जो मैजिस्ट्रेट्स हैं उनकी ट्राई करने की पावर क्या है. तो रिमेंबर दैट फर्स्ट शेड्यूल में वो लास्ट में लिस्ट ली गई. आई टोल्ड यू इन द लास्ट कॉलम इट इज ऑल्सो रिटन एज टू विच कोर्ट इज गोइंग टू ट्राई देम. सो विच कोर्ट इज गोइंग टू ट्राई देम, वहां ये लिखा होता है कि भाई सेशंस कोर्ट है या जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास है या सेकंड क्लास है. सो यूजुअली व्हेन यू लुकिंग एट जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास, इफ देयर इज अ पर्टिकुलर रॉन्ग जिसके लिए पनिशमेंट इज 1 year एंड द फाइन इज 3,000, तो इतनी पनिशमेंट जो है जुडिशियल मैजिस्ट्रेट सेकंड क्लास दे सकता है. सो एनी ऑफेंस व्हिच इज पनिशेबल विद offense up to 1 year and 3,000 rupees fine, the judicial magistrate second class will look at it. If it is more than if it is 3 years and 5,000 rupees fine, then it is going to be the judicial magistrate first class. CJM, chief judicial magistrate, भी एक judicial magistrate first class होता है. So it is going to be the same thing which will apply, right? उसके बाद आपका सेशंस जज आता है. सेशंस जज हैज पावर टू हियर ऑल केसेस, राइट? तो कोई भी पनिशमेंट कितना भी हो, इसके पास पावर होती है सारे केसेस सुनने की. सो इवन इफ इट्स अ मर्डर व्हिच हैज हैपेंड, द सेशंस कोर्ट विल हैव द पावर टू हियर द मैटर. द ओनली थिंग इज दैट इफ इट इज एनी मैटर जहां आप डेथ पेनल्टी दे रहे हो या जहां पे आप लाइफ इम्प्रिजनमेंट दे रहे हो और द इम्प्रिजनमेंट इज मोर देन 7 years, then in that case this has to be approved by the high court. तो जिस भी सेशंस हाई कोर्ट के नीचे ये सेशंस जज आया है, the sessions court is there, you will need an approval of the high court before you give this punishment. You have the right, but it is subject to the approval of the high court, right? So अगर मान लो मर्डर का ट्रायल हुआ है, इसका ये मतलब नहीं होगा कि हाई कोर्ट में केस चला जाएगा. केस तो सेशंस जज ही सुनेगा, बट वो सेंटेंस की जब अप्रूवल की बात आएगी तो वहां पे हाई कोर्ट से आपको अप्रूवल लेना पड़ेगा, राइट? यस हसिका, द समरी केसेस आर सॉल्व्ड बाय मैजिस्ट्रेट्स. यस, बिकॉज अब देखो 1 year 3,000 rupees है, तो फिर दे आर पेटी, छोटे छोटे मैटर्स हैं, राइट? सो देन दोज आर हर्ड बाय द जुडिशियल मैजिस्ट्रेट second class, right? So this is a broad hierarchy. See, this is very very important because end of the day you want कि criminal justice जो है this has to be dispensed equally everywhere. It should not be कि कहीं आप dispense कर रहे हो कहीं आप dispense नहीं कर रहे हो. In fact, एक और चीज to ensure that fairness is always there in criminal trials, there is this section 482 of the CRPC which gives the High Court with certain inherent powers. Basically it is talking about the power of the High Court to, wherein it sees that any kind of injustice is being done, any kind of abuse of process is being done, you can directly go to the High Court under Section 482. Now, if you are reading newspapers, I'm sure you must have come across Section 482. मुझे कोई बताएगा ये Section 482 कहाँ ज्यादातर यूज होता है? Where is this normally used? It is very, very commonly occurring section of the CRPC. It's splashed over the newspapers very often. You see, when you're reading any kind of blogs on criminal law, you come across this very often. Can anybody tell me kahan pe ye padha hai aapne? Kahan pe? Because we haven't studied in your classes, wherever you are, you've not really studied this, but this is something which does come in newspapers a lot. No, Hasika, not DPSP. कहाँ यूज हुआ है ये 482 ज्यादा? Have you heard of this concept of quashing of FIR? भाई इस केस में FIR quash हो गई. तो जब आप FIR quash करने जाते हो हाई कोर्ट में, तो आप कहाँ जाते हो? आप जाते हो अंडर 482. बिकॉज आप क्यों quash कर रहे हो FIR? कि भाई अब्यूज हो रहा है प्रोसेस ऑफ लॉ. Right? There is something which is wrong which has happened. And it is not limited to quashing of FIRs only. It could be wider than that. Right? Let's say if there is a case which is going on and I am, let's say, I am the accused and I have not been given the right to bring my witnesses. Right? केस ऐसे ही चलता जा रहा है और जब भी मैं बोल रही हूँ मुझे अपना विटनेस लाना है, कोर्ट मना कर देता है, कोर्ट रिजेक्ट्स इट on some ground or the other. So I feel there is an abuse of process of law which is happening. So what can I do? I can directly go to the High Court, because this is the provision of the High Court wherein it is trying to do justice. कि भाई अगर justice जो है वो missing हो गया है, तो ये justice जो है लोगों को मिलना चाहिए. अब ये justice लोगों को कैसे मिलेगा? अगर नहीं मिल रहा है तो आप जाओगे High Court में under Section 482. And that is why these are very immense powers with the High Court to do justice, to ensure कि भाई abuse of process of law जो है नहीं है, and to ensure भाई justice जो है लोगों को मिल रहा है. Very, very important power which the High Court has, which has specifically been given for criminal cases. Right? ये अगर आपने if you followed those Goregaon cases, the Bhima Goregaon cases and all those, if you followed, you would have come across this. And otherwise also, a lot of politicians, political parties के या politicians के cases होते हैं, वहां आप ये 482 quashing of FIR का पढ़ते हो. I would recommend कि इसके बारे में थोड़ा सा, if you don't know about it, read about it a little. This is very, very commonly topic जो कि newspapers में या फिर current legal affairs का part है. Right? So do the Yes, Supriya, this is something similar to 142. 142 में वो सुप्रीम कोर्ट की पावर है टू डू कंप्लीट जस्टिस, राइट? बट यहाँ वहां पे जब आप 142 की पावर देखते हो, 142 में सुप्रीम कोर्ट के पास पावर है टू पास एन ऑर्डर, नॉट टू हियर अ मैटर, राइट? यहाँ पे जो है इट्स टू हियर अ मैटर ऑल्सो. Right? 142 की power normally आती है inherent power of the Supreme Court to do complete justice. Right? So that is very similar to 482. 482 is for criminal cases only. Okay. अच्छा, अब आ गए. Yes, High Court has the power to quash FIR. Yes, that's exactly 482 की power यही है कि अगर आपने FIR पुलिस ने गलत फाइल करा है, right? Then if you can bring evidence कि भाई ये FIR बिल्कुल गलत है, झूठा FIR है, पुलिस मुझे तंग कर रही है, then the High Court can actually ensure that the FIR is quashed. Right? So that is something which is there under 482. Achha, I will just take up something which was asked, that was compoundable offenses. Hasika was asking me, ma'am, compoundable offenses or non-compoundable offenses क्या होते हैं? अब normally जब आप offenses की बात करते हो, criminal case की बात करते हो, then offenses क्या compromise parties को करने देना चाहिए? That is the basic idea about compounding. Compounding is कि आप केस वापस ले रहे हो and parties का आपस में compromise हो गया. अगर civil suit है तो कोई प्रॉब्लम नहीं होती, because they are just parties involved in the case who are getting affected. So even if you compromise, there's not much which happens. But if it is a criminal case, and if it is a serious criminal case, imagine, then should compounding be allowed? Should the parties be allowed to come to a compromise? The answer is a no. So compounding is basically reaching a compromise. तो जब आप compromise बोल रहे हो और अपना केस वापस ले रहे हो, ये सिर्फ allowed होता है offenses which are not very serious, right? So compoundable offenses are offenses in which compromise is allowed. You can take your case back and the party will not be prosecuted against जिसको जो भी accused है, but this is allowed only in very non-serious sort of offenses. जहाँ serious offense है वहां हम बोलते हैं कि क्राइम इज अ सोसाइटी एट लार्ज के अगेंस्ट जो है ये आप क्राइम कमिट कर रहे हो, तो वहां पे पार्टीज को आपस में कॉम्प्रोमाइज करना अलाउड नहीं है. समथिंग इमेजिन देयर इज अ रेप केस, देयर इज अ 5-year-old गर्ल हु हैज बीन रेप्ड बाय अ मैन. नाउ दिस मैन इज वेरी रिच. तो पहले तो उसके पेरेंट्स ने, गर्ल के पेरेंट्स ने केस फाइल कर दिया रेप का कि भाई रेप हुआ है. उसके बाद दिस रिच फेलो गिव्स देम 20 लाख रुपीस एंड दीज पीपल आर पुअर कि ठीक है तुम 20 लाख रुपए रख लो, अब ये केस वापस ले लो. शुड दिस बी अलाउड? Would this be just? Would justice be done if compounding is allowed in such a case? What do you think? No, obviously not. That is why compounding or compromise is allowed only in non-serious offenses. जहां serious offenses है वहां पे compounding allowed नहीं होती है. ठीक? Okay. So that is one thing. Now these are topics which I know you have already done somewhere or the other, right? So I've just mentioned them here. Double jeopardy normally आपके article 20 में भी आता है. Section 300 of CRPC also is double jeopardy, but this is wider, right? यहाँ ये wider है in the sense कि अगर आपका prosecution हुआ है, फिर conviction हुआ है या acquittal हुआ है, in both the cases you cannot be tried again. Article 20 जो है वो limited है. Article 20 में क्या होना चाहिए? Prosecution along with conviction or acquittal कि trial retrial ना हो. In double jeopardy under Article 20 it's supposed to be limited. So you prosecution of course is going to be there कि आपका prosecution नहीं हुआ है, plus should you be acquitted or should you be convicted? Which one of the two is there? Prosecution के साथ acquittal होगा तब double jeopardy लगेगा या prosecution के साथ conviction होगा तब double jeopardy लगेगा? Come on. वहां पे PP लिखा होता है, prosecution and punished. तो पनिशमेंट कब मिलती है आपको? अक्विटल पे या कन्विक्शन पे? पनिशमेंट कब मिलती है? जब आप अक्विट हो गए हो, ऑब्वियसली जब आप कन्विक्ट हो गए हो, right? So when you are talking about Article 20, it means you have to be prosecuted, then you have to be convicted, only then you cannot be tried again. But it is wider again under Section 300 of CRPC, जहां पे चाहे convicted हो, चाहे acquitted हो, if you have been tried once, then you cannot be tried again. इसमें वो maxim आता है आपका autrefois convict and autrefois acquit, right? So if you have been convicted once, you have been acquitted once, you cannot be tried again, right? Okay. फिर आता है आपका right to maintenance. ये भी एक important provision है CRPC का. In fact, this is one of those provisions जहां पे आपको एक substantive right दे रहा है. Procedural law is CRPC. It's not a substantive law, but it is giving you a substantive right, right? So it is giving you a right under like a substantive law, because 125 में क्या बोलता है? That it is the responsibility to maintain your wife, your children, your parents, right? So if you are not maintaining any of these three, and if they are dependent, right, and they have no other means of sustaining themselves, then the wife, children, or parents, they can file a case against you to claim maintenance, right? तो 125 में आपका right of maintenance है, जो कि एक substantive provision है under CRPC. Similarly, जो आपका right to bail होता है, वो भी substantive provision होता है, right? So you have the right to bail. कहाँ right to bail होता है? Normally in cases where we are talking of bailable offense, right? Bailable offense में आपके पास right होगा bail का. Otherwise, non-bailable offense में तब भी there's this concept of default bail. This also has been in news. This past 1 year, this also has been in news, the concept of default bail. Can you tell me default bail का concept कहाँ news में था? कहाँ था ये news में default bail का concept कि भाई एक बार 60, 90, 180 days हो गए हैं अरेस्ट के, फिर भी चार्जशीट आपने नहीं फाइल करी है, तो आपको क्या मिल जाएगा? डिफॉल्ट बेल, right? So if such a long time period has passed, and because the police is supposed to do investigation quickly and file a charge sheet, अगर चार्जशीट फाइल होगी उसके बाद आपका हियरिंग ऑफ चार्ज रहेगा, तो आप डिस्चार्ज हो जाओगे या केस चलेगा. बट कोर्ट जो पुलिस जो है वो डिले कर रही है, इज नॉट फाइलिंग अ चार्जशीट, एंड द पुअर गाय जिसके अगेंस्ट आपने केस फाइल किया हुआ है वो cognizable offense, the guy is arrested and is put behind the bars, and the police is not doing anything. So in effect, what is happening? The fellow is behind the bars for no reason, right? Only reason is the delay on the part of the police, mismanagement on the part of the police, right? So that is the reason यहाँ पे ये default bail का clause होता है, that at the end of these periods you can get, if no charge sheet is filed, you can get a default bail. Yes, Supriya, you're right. The Kanhaiya Kumar case, all those Bhima Koregaon cases, वहां पे ये default bail का जो case है, ये काफी news में रहा है, right? So this is again one concept जिसके बारे में आपको थोड़ा सा idea होना चाहिए, right? अगर 2020 type paper आया तो बॉस ये सब पता होना चाहिए थोड़ा बहुत, right? चलो, I hope this session was helpful for you guys. We are done with CRPC. Okay. Next class, what we are going to do is we are going to do the next set of procedural laws. We will do CPC and we'll do the Limitation Act. Right. I hope everybody is clear with whatever we've done. And, as all of you are aware of, who are here especially, that we are doing this session on miscellaneous laws. So every Thursday, and like I told you, Karwa Chauth, I'm wearing all this jing bang today with bindi and stuff and sitting in front of you talking when my throat is parched, because every Thursday we are dedicated that we are going to deal with miscellaneous laws for you. Right? तो miscellaneous laws के हसिका अभी मैंने भी लिस्ट नहीं बनाई है, frankly, I think, because sometimes I think कि मैं procedural laws एक session में कर लूंगी, but when I start digging into it, I realize that you need more than one session. So we might have another 3 or 4 sessions on miscellaneous laws, right? So this was your session on procedural laws. We did CRPC today. Next time we're going to do some other session. If you are new to our channel, if you are not one of my students who's been saying thank you to me, if you are new to this channel, I hope this session was interesting and informative. So if you feel you need some more help on miscellaneous laws, we have this every Thursday session. We've covered IPR, environmental law, family law. We've done it in great detail. You can find the links in the description box with this particular session itself. Go watch those videos and you would be in a better place so far as your preparation for CLAT is concerned, right? Other than that, if you feel you need any help regarding your CLAT preparation, please feel free to contact us. These are our social media platforms. We would love to see you there and hear from you there. Okay. So that's me, Neha, signing off for today. To see you next week. Next Thursday, we would be doing CPC and Limitation Act. Okay. So you have one whole week before you get to see me. Thank you so much, everybody, and take care. Bye-bye.